court was informed from the bar that the High Court in application, within the application for review to the Chief Justice to empanel a bench of 3 judges to hear the constitutional application, my order has not been set aside. In the case law of Society of Kenya versus AG and Central Organization of Trade Unions, the Supreme Court in petition number 4 of 2019 at paragraph 91 gave directions on what a judicial officer should do on learning of an appeal preferred on the same subject matter before it. I am aware that the above mentioned revision is pending before the High Court, and I take judicial notice of it. The determination therein may as well have a bearing on the requirement of disclosure count by count, which this court has interest in. The court is proceeding on leave within a week. The said information the information is that the matter is coming up before the Honorable Judge on 17th of December 20. Evidenced by the prosecution, accused 1 produced a signal, a certificate of good conduct, identification showing him as a member of the International Police Association, and also informed the court that he had been honored with the award of the Elder of the Burning Spear, and that accused 1 was an holder of an award of Good Deeds Ambassador by the UN. The respective agencies that either gave him the clearance certificate or the awards know better the reasons why they gave him the clearance certificates or honored him, as courts only give pronouncements based on evidence. After having considered all the material placed before me, I am of the considered opinion that all accused are hereby admitted to bail terms. These bail terms must be adhered to the letter. Any violation shall lead to cancellation of the bail terms. In terms of companies charged, I have considered that they are legal persons who cannot be sent to jail. Hence, the bail terms will be a consolidation to be met by their legal representative. To be very clear, the bond terms on the legal representative alone will suffice for the limited liability companies. Now, the accused are admitted to the following bond terms. Accused 1 to a bond of 30 million with 1 surety of similar amount and a cash bail of Kenya shillings 15 million. 3 million with 1 surety of similar amount or to a cash bail of Kenya shillings 3 million. For accused 10, 11, 12, 13, 14, 15, 16, and 17 to a bond of Kenya shillings 30 million with 1 surety of similar amount or a cash bail of Kenya shillings 10 million. The accused who have not taken plea will only have their bonds processed after plea. All parties in the case, including but not limited to the office of the DPP, the EACC, the accused, are hereby prohibited from commenting on this case on social media in whatsoever manner, and that should be taken seriously. The court, by virtue of the above pronouncements on Ngugi J and Ngenye J, directed that accused be barred from office. If need be, he can be escorted. The court, by virtue of the pronouncements of Ngugi J and Ngenye J, directs that accused 1 be barred from office. If need be, he can be escorted to his office by the IO, in this case, or any other authorized officer to enable him access and pick his belongings. 1 is hereby required to ensure that his supporters do not cause disruption to any non-legal process or disrupt peace in whatever form. All accused to deposit their passports and all traveling documents in court. In any case, the Director of Immigration is directed to ensure that none of the accused leaves the jurisdiction of this court without the permission of the court. For this purpose only, the order herein shall be extracted and served on the Director of Immigration. All accused are barred by themselves or by proxy from communicating or approaching any witness in this case in whatever manner. The orders herein apply mutatis mutandis to ACC case number 31 of 2019.